Right. Very good afternoon, ladies and gentlemen, joining us this beautiful of May 2026. It's quite an honor to have you all join us this afternoon.
Have we lost?
Yes, I think we've lost Gabriel.
Okay.
Gabriel, we've lost you. Brina, are you there?
Yes, please. In the meantime, probably we could start us off. You can start us off, Chair, and then Gabriel will be back.
Okay, that's in order. Thank you. Good afternoon, colleagues. Welcome to today's webinar on who is really the boss in the digital workplace, AI surveillance, gig work regulation, and employer liability in the new labor economy. My name is Lilian Oluochwambi. I'm the chair of the East African Law Society Employment and Human Resource Committee and a partner at Oluoch Kimori Advocates, and I have the privilege and the pleasure of moderating today's session. The topic of today's webinar is both timely and deeply significant, not just across East Africa, but across the world. Technology is fundamentally reshaping the workplace from how workers are recruited and supervised to how productivity is measured and even how disciplinary decisions are made increasingly. Algorithms and digital systems are no longer simply tools supporting management. In many respects, they're becoming active decision makers with employment relationship. With us today, sorry. So before we begin, a brief note on participation. We encourage active engagement from the participants. All questions should be posted in the question and answer section, and participants are kindly requested to specify clearly the panelist their question is directed to. This will help us ensure a structured and efficient discussion. And we will now hear from all the distinguished panelists, and I will introduce each speaker immediately before their respective session. Thereafter, we will open the floor for questions and audience engagement. With that, let us begin our discussion. And our first speaker will be Ms. Irene Kashindi. Ms. Irene Kashindi is Just give me a minute to get okay. Ms. Irene Kashindi is an advocate of the High Court of Kenya with over 17 years of experience and a partner at MMK Advocates, where she heads the Employment and Labor Relations Practice Group. She's a highly respected employment and labor specialist, currently serving as a member of the International Labour Organization Committee of Experts on the Application of Conventions and Recommendations. Ms. Kashindi also holds an LLM in Financial Services Law and is currently pursuing a doctorate in law at Strathmore University, focusing on the intersection of labor law, technology, and artificial intelligence. In addition to her distinguished litigation practice, she's also a fellow of the Chartered Institute of Arbitrators and has consistently been recognized among Kenya's leading employment lawyers by Chambers and Partners and Legal 500. She's also a published author and a frequent speaker on employment and labor law across the region. She will speak on control without managers, who really exercises authority in the digital workplace. Ms. Irene, you can proceed.
Thank you so much, Council, for the introduction. I was trying to, I hope I can be allowed to put off my camera at some point so that I can just concentrate on the presentation. But the presentation that I have today is, as Council has said, presenting on control without managers, who really exercises authority in the digital workspace, within the larger theme or broader theme of who is really the boss in the digital workspace, and the employer. Is it the employer or is it the algorithm? And thank you so much, the organizers, for inviting me to be part of this panelist. It's a topic that is close to my heart, not only from a professional perspective, but also from academic perspective, because I'm pursuing my doctoral studies on some of the things that we will discuss today. So yes, I'm passionate about training. I'm passionate about sharing knowledge. And every time the East African Labour Law Society asks me to make a presentation, when my time allows, I always make time to do so, because as part of what we do in MMK Advocates is training and capacity building. The slides before you shows our key practice areas is training and capacity building, which is what I do a lot as well in the employment and labor space, but also we are also very key actors in the employment and labor relations space in the country and within the region. So without much ado, and yes, I am an author. Every time I have a platform, I say, yes, I've written a book, because writing a book is not very easy, and I've written two, Kashindi's Digest for Employment Cases. For my colleagues that are from Kenya, I'm sure you know about that. And if you'd like us to engage about that later, we can do that when I share my contacts towards the end. So this is the presentation that I will spend the next 15 minutes. I've been given 12 to 15 minutes to take care of the presentation that I have. So I'm going to try as much as I can. I have really a lot to say, but I'll try as much as possible to say the much I can in this short period that I have. So we are talking about, and let me actually do maybe a presentation slide to make it easy to follow. So I was going to start off with sort of like laying the context and giving statistics, but maybe time will not allow. So let me just say one or two things in terms of statistics. That in Kenya, let me say Africa generally, we are looking at very high rates of two very high rates. We're looking at very high rates of unemployment. We're also looking at very high rates of informality. Compared across the world, we are looking at a rate of informality at almost 80%, meaning that less than maybe 20 or so % are jobs that are actually available in the formal sector. And yet we have a very high informal sector. What does that mean in the context of what we're discussing today? It then means that there are new models of work that are coming up. We'll discuss some of them today, including digital gig work, that then seem to be taking care or coming to remediate this very high unemployment rates and also very high informality, so that they introduces some new model of employment. But what does that mean in terms of control? And that brings us to what we call algorithmic management. You'll hear a lot about that, I'm sure, not just from me, but from the speakers that will follow. That algorithmic management, what does it mean? It could be a big word, but it just literally means the use of AI systems, algorithms, data analytics to do what it is that human beings have traditionally done, to allocate, supervise, evaluate what conventional management structures have been doing in the past. But because of digital technology advancements in literally, I think, all parts of the globe, then we have a lot of algorithmic management in our workspaces and in the world of work. I'm actually saying workspaces and world of work deliberately, because workspaces are no longer, where we work nowadays are no longer just constrained to workspaces, but it's much broader, as you will shortly see, and therefore making, algorithmic management an important discussion to have at this point within the context of who exercises control? Is it algorithms or is it human beings? And why is it important? My presentation will feature on 3 models of control, 3 models of labor control, if I would call it that way. And I'll talk about the conventional employment relationship. So the employment relationship where we know there's a clear employer, there's a clear employee without any, contestation as to whether is this an employment relationship or not. And that's why I'll keep calling it a traditional or conventional employment relationship, where there's an existing management or managerial hierarchy of employer-employee, but increasingly we are seeing a lot of use of AI and algorithmic management at the workplace. So that is truly a workplace. But we're also seeing a lot of algorithmic management used in sort of like emerging ways of work. Outsourcing is not new, but there are new ways in which it's being structured. So we are looking at business processing, outsourcing, BPOs, employer of record. I don't know whether you've had this issue of employer of record. It's becoming a very common way of structuring labor at the workspace. It's really just a form of outsourcing where you have an employer of record and you have another, let's say, employer who the employer of record sort of like outsources employees to. And then, of course, that creates the question of who really is the employer here in an outsourcing BPO or an employer of record setting. And we are actually seeing that similarly, we have algorithmic management playing a very key role in as far as these new models or evolving models of work. And then there's also the 3rd model, which is platform or digital gig work. I think most of us would understand it from a gig economy, but we're talking more from a digital gig economy, or what is known in this space as platform work. And work is where work is coordinated through algorithms, apps, and it's often structured in an independent contractor model. So not the traditional employer-employee model, but where the platform worker is classified in most jurisdictions as an independent contractor, including our own Kenyan jurisdiction, though there are some changes that are in the pipeline that are proposed. But this is still evolving in many jurisdictions. So there's a shift where we have algorithmic management. You have a lot of algorithmic management and AI and the use of digital systems to undertake roles that ordinarily would be done by humans because of the technological shifts. So it's such that now authorities no longer solely undertaking by human through human control. There's a lot of rise of people analytics. The workplace becomes a much more boundaryless. And then there's also an interlocking tiers of employment where there's a shift from the long-term sole employer, if I would call it that way, where now we have interlocking tiers of employment. In some places they've been called multi-homing, where multi-homing just pick it from the word home. So you actually multi-homed. You have different homes where you're working. In other nomenclature is called multi-homing, but there's also a lot of flexible working. But let me go to the substance of it, is that the specific realities of algorithmic management, especially in human resource management. So I'm here focusing on traditional work arrangements, where I started from when I gave those 3 categories. And the new faces of the new boss, and I'm putting new boss here deliberately because I'll discuss later when I reach to my conclusion, as is there a really new boss or is there a new way of managing the workspace? So we are seeing increasingly, and it used to be that this is something that is happening in the West. When we started talking about algorithm management and AI, most of the discussions maybe a couple of years ago was these are things that are happening in the West, but they are now actually happening literally next door within our own African setting, within our own East African setting. We have several clients where we are actually advising from an automated recruitment processes. So AI is involved in the recruitment processes. It's also involved in, just onboarding the employees in the entire recruitment process, including, negotiating specific works of work schedules. So scheduling work. Scheduling work is increasingly also being automated. Attendance at work, I think this has been common, like this in most workplaces, because biometrics are used to monitor attendance. What time do you come in? What time do you leave? Allocation of tasks, I think that relates to scheduling. And performance tracking, scoring, and review. That we are increasingly seeing that, where the aspects of that are also automated in the traditional workspace, including scoring, performance review, scheduling, giving, feedback to the employees when they are, for example, being put on a performance improvement plan, an employee being put on a PIP, being monitored through technological platforms, which is a role that would traditionally be undertaken by a human being. Remuneration as well. Structure, compensation structure, is also undergoing, some changes, and where algorithms are also playing a role here. Sanctions, also imposing sanctions, automated imposition of sanctions and penalties, deactivation of, digital platforms, though that is, I think, much more common in the platform economy. We'll see shortly, appeal processes, and so on and so forth. So here the algorithm is taking control, or some sort of control, by being a scheduler, an allocator, supervisor, controller, an evaluator, or a disciplinarian in the traditional work setting. So what is happening in the digital platform? In the digital platform, we would see that authority is actually predominantly exercised in digital platforms through algorithm control, especially, the most common example I would give is the ride-hailing platform. It's the digital platforms or the algorithms that would determine, for example, if you're taking a ride, who is your rider? You as a customer, and how much are you paying to the rider? Issues to do with deactivation of the system, depending on, of course, the platform's rules and so on and so forth. Commissions, how much, calculating commission and compensation, and so on and so forth. So that's the best example of how algorithms are actually playing a role from a platform perspective. Food delivery, we've seen that as well, working in the same manner as ride-hailing. E-commerce and logistics platform, we know Jumia, for example, let me use that, what is common in Kenya. Jumia, ride-hailing, we have many ride-hailing that I think apply across the board in East African setting. Uber, Bolt, we used to have Little Cab and such kind of ride-hailing platforms. And freelance or digital labor platform as well, they are also on the rise in as far as mediated work in the platform economy is concerned. So how does this then sort of like implicate or affect the traditional control, the way we know it from an employment setting? I think most of the countries that we have in the East African region have a common law background, so they would really, but I think this may also apply in the civil law setting, but the common law background of who exercises control is actually the employer. And we know the control test, we know the economic reality test, and we also are aware of what in our Kenyan courts, and I think even the old foundational English cases, I put two of them there, Yewen's case and the ready mixed concrete. It's some of the two cases from a common law perspective that are widely cited on who an employer is. An employer is a person who exercises control. There's this case of Kenneth Kimani Mburu versus another, where I represented one of the parties some years ago, and this case from a Kenyan perspective distills this control test, economic reality test, multiple tests, and so on and so forth. Why am I highlighting this? I'm highlighting this because algorithmic management in all those facets, whether it is in the traditional sense, whether it's in the platform sense, whether it is in the outsourcing sense, and any other new models, are actually then testing this worker classification test the way we've known them, and we are looking at test control in a bit of a new light. And you will see shortly. I know I'm moving a little fast because of time. You will see that there's because of now algorithmic management and the changes in which control is exercised at the workplace, questions are being actually asked as to who really then exercises control. And that question then, connects to another question that if a platform is exercising control, does that mean that that platform is now the employer? And then if that is answered, then if that is the employer, then what obligations and responsibility does that employer have? So certain resultant changes in this control perspective that are changing. Digital surveillance means that there's perpetual control. There could be perpetual control in certain circumstances, especially when there's surveillance, there's cameras, there's keyboard registers. We also have wearable tracking and nudging, which is now, that means that there's behavioral control. We also have, other biometric control where there's now hierarchical control. So different ways or different modes of control that we are seeing at the workplace. Let me not focus on that. I try to wind up my conversation by maybe just looking at a clean sweep. If I could just be given another less than 5 minutes, I'll be done. I know my time is, I have like 2 minutes, but if I could just be added another 3 minutes so that then I bring this home, I hope that is okay. So what is happening in regulatory perspectives on how then algorithmic management should be regulated? Many parliaments across the globe, including in our own, not even just parliaments, let me say policymakers and stakeholders are grappling with the need to regulate these aspects of control, which are rising every other day. So quickly, just seeing from what is in the global north, then we'll come to the global south, then we'll come to East Africa, and then I'll end with what is happening in the international labor space. Is in Europe, we must have heard about the Platform Work Directive, which creates a rebuttable presumption of employment and also has provisions on how to deal with algorithmic management and transparency in such processes. The EU GDPR also has provisions on automated decision making, prohibiting decisions such a decision should not be solely made based on automated decision making without human intervention. The EU AI Act also classifying employment as a high risk, so certain aspects of employment as a high risk, requiring transparency, human oversight, risk management, and accountability because of that classification. In Spain, we have what we call the Riders Law, arose from this lay rider a case that went through their court system, but this also then talks, it's a very interesting way of looking at it, because this law then requires platform to share logic of algorithms with union. So collective bargaining coming into play about, the control that algorithms exercise and how unions can then have a say. In the UK, there's 2 cases. I may not have a lot of time to go into it because I had gone a bit into detail, but there's 2 cases. The Uber Aslam case that happened in 2021, where the court went so much into addressing whether Uber drivers, the Uber drivers that had moved to court, were categorized as employees or workers. Because in UK, we have 3 categories. We have employees, we have an intermediate worker category, then we have independent contractors. The issue here that happened in this court, that this case that went all the way to the Supreme Court, was that the court then said that Uber workers were workers, this intermediate category, meaning that they were entitled to certain rights, minimum rights, let me call them core rights. And if you sit down and you read that decision, it actually turned on the issue of control. That case actually calls this subordination of the Uber drivers to the platform, meaning that they were actually workers in the sense that they then were entitled to these rights. And therefore, the court then said, oh yeah, the control test, so to speak, we'll call it that way, of subordination, meant that they were workers. But subsequent to that, there was the Deliveroo decision that was in 2023, though it was looking at a slightly different things, but still very important from an algorithmic management perspective. In the interest of time, I may not be able to highlight it. In winding up, let me highlight what is happening in Africa generally, and maybe Kenya and a bit of East Africa, is that in Kenya, we have currently there is a debate or an engagement to re-look into our employment laws, such that then there's a proposal to create an intermediate category of workers, if I would call them that, dependent contractors, so that they are not fully employees, but they are also not the independent contractors, but they are independent. They are dependent contractors, and the paperwork or the policy documentation that I've seen that sort of like support this proposal is the recognition that platform workers do not neatly fall within employment category, but they also face a lot of control with their work, and therefore they can't really be independent contractors. So there's a proposal to create this sort of an intermediate category. The same proposal also talks about having provisions in the law to ensure transparency, fairness, human oversights whenever automated decision making are made. So the issue of control. So that's what the proposal also has. And then there's been a bit of case law that has gone to court. One of them that I can highlight is a recent petition that went through our court system last year, and it sought to challenge a proposed law, if I would call it that way, on grounds that it proposes to shield foreign tech firms of global firms operating in Kenya from prosecution over labor and human rights violation. And the bill here was, and I can see you, Lillian, I'll be done in less than 2 minutes. The bill here was proposing to then describe who would be liable in an outsourcing setting. And the case went to court, but the court found that it was premature for the petitioner to have gone to court at this point, because the bill was still under active consideration by Parliament, and therefore the court did not make any definitive findings. There's also the Meta case. I think that is widely known. It has also been not definitively been determined through our court system. Initially, the Employment and Labor Relations Court had actually determined that both Meta and the outsourcing firm, I think Sama, were employers in a co-employment kind of setting, if I would use it that way, because of the control that Meta exercises over the petitioners who had gone to court. But that decision was made at an interlocutory stage. It went to the Court of Appeal, and the Court of Appeal said the Employment and Labor Relations Court ought not to have made such substantive findings at the interlocutory stage. So the matter is back in the Employment and Labor Relations Court, which is a case that we are very keenly following, because it will really, I think, shape jurisprudence in as far as control, especially in an outsourcing setting, is concerned. Let me end by what is happening at the International Labour Organization. There is a draft, there's a proposal by the International Labour Organization to come up with a specific instrument that then regulates platform work, or work in the platform economy. It's decent work. The real name being used is decent work in the platform economy. And some of the provisions that this draft convention has to do with how to regulate algorithmic management at the workplace, to govern platform work, such that there are issues on transparency, human oversight, right to explanation, right to appeal, and so on and so forth. So in conclusion, who truly exercises control? One, in the traditional workspace, it's not that the employer has lost control in the legal sense, but the employer is undertaking certain managerial processes using automated processes, including AI, that then means there's questions as to who truly is exercising control. Is it the employer? Is it the human employer, or is it a platform? But from our Kenyan perspective, we have the Data Protection Act, for example, has restrictions on automated decision making, which is a law that can still be applied even as we wait for more comprehensive laws to be in place to deal with this. And the conclusion number 2, and the second last one, is that in outsourcing or PBO or an employer of records or similar mediated structures, managerial authority is increasingly becoming an issue that we must all follow. And this was the issue that was really the Meta decision, and therefore making the questions on accountability, employer responsibility, something that we must continually have conversations on. And thirdly, of course, now platform work, digital labor models. These new digital labor models bring to the fore as to whether the old classification tests of control would neatly fit within these new models of work, or whether the law needs to look at it more differently. I will stop there, and maybe we can engage further during Q&A. Thank you so much for allowing me to go a bit over in a few minutes. I had a little more to say, Lillian, but I'll stop there in the interest of time. Thank you.
Thank you so much, Ms. Kashindi, for that very clear and framing of how authority is evolving in the digital workplace. Colleagues, please feel free to just post your questions in the chat box, that is the question and answer section, or even your comments in the same. Our second speaker, that is our next speaker, is Ms. Alice Namuli Blesvig, a partner and head of technology and innovation at Katende Sepembo and Company Advocates in Uganda. Ms. Blesvig is an internationally recognized technology lawyer, innovator, and thought leader with over 18 years of experience at the intersection of law, technology, and digital transformation. She specializes in artificial intelligence, blockchain, fintech, cybersecurity, data protection, and emerging technology, and has advised some of Africa's leading technology-driven businesses shaping the future of commerce on the continent. She was recognized among the top 5 most influential women in legal tech globally by the International Legal Technology Association, and she continues to play a leading role in advancing legal innovation across Africa through various initiatives and institutions. Please join me in warmly welcoming Ms. Alice Namuli Blesvig to address us on employer liability in the age of AI. Who answers for the algorithm? Over to you, Ms. Blesvig.
Thank you very much. I'm a bit speechless. Can you see me?
Yes, I can see you clearly.
Yeah, the previous speaker basically, took like 30 minutes. And I think she spoke on behalf of all of us because she's literally taken up, but I think it's perfectly fine. So my presentation has, I mean, most of the information literally she has already shared. So I'm kind of struggling to literally not to repeat myself, or rather to repeat what she said. But maybe what I could just say is just really pretty much to emphasize that it's very clear, and I think we all know where we are at right now and what is going on and what is happening in our in our workspaces. And I don't think we can avoid whatever is going on right now, or the impact on AI, on how it's shaping our workspaces, from recruitment, preparation of our CVs, from whoever, like the interview process, all these things. I'm sure all of you have noticed that there's some AI or some kind of algorithms that are used to come to certain decisions. And in majority of the time, you'll find that we get like accurate answers, or like 99% accuracy, but there's still the question of what happens in case that there's 1% of inaccuracy or some errors after you've used AI platforms, because this usually affects human beings. It affects people's lives. So now the question, the main question we usually should right now, whether most employers are asking themselves and employees, or pretty much the world, who takes responsibility when all this, takes place? And I don't think we are going back to, the ordinary way we used to, or employers used to either hire or monitor performance and evaluation. I don't think we are going back. But now the question is that what happens when you have like an automated decision? It has been sent to you, you're noticing like glaring ethical concerns, or even just, day-to-day work, and your manager or your employer is insisting on following the results that have been given by an AI platform. But the previous speaker spoke about the fact that actually we have a gap, a lacuna in our regulation, that there's no specific laws that we have in East Africa. Within East Africa, I come from Uganda, so we don't have anything in place to specifically address this concern, the ethical issues that arise from the use of AI platforms. So because there's a lacuna and there's a gap, no one really knows pretty much what to do. What in an ordinary circumstance, I think the best thing would be to use some of the regulations we have. I know rather for certain, most of the East African countries, we have strong data protection regulations. That is where usually I would say we should borrow most of the provisions in there that especially relate to the control of data. Because when you think about it, all AI platforms are going to use data. They're going to use access our data, and they must our data protection regulations within East Africa generally, for all those countries that have them in place, or that are following the African Union data protection and cybersecurity framework. You find that you must at least follow the data protection regulations of that jurisdiction, and it all starts from at least have all the employers, all the information and the data you're collecting on behalf of your employers, rather employees, have they given you consent? So in there, I feel like because we don't have a specific law, we can still borrow from the regulations that are in place. And what I want to mainly focus on is the liability question. So you have to ask yourself, yes, in case you've been given a decision, a decision has been made and there's an error, who should you blame? Who should be responsible for the error? Who should you sue? Globally, some, of course, now courts are benchmarking and using global examples. Currently, I'm based in Toronto, and I'll give you, for example, a case which is going on right now for a hospital where the hospital hired an AI platform, which of course it's a company which was using an AI platform, which was required to take samples from mothers to test if they had used any kind of like drugs or any substance abuse. But then it turned out, of course, there were errors in the AI platform they were using. Now the case is in court, and the question now is the people, the contractors who are using the AI, AI platform are insisting that it should be the programmers of the platform who should be liable. But then the plaintiffs are insisting, these are the people who are the mothers who are affected by these kind of decisions, are insisting that it is the contractors who actually purchased the platform. They are the ones who should have known that this platform is erroneous, and they should never have used it. So back to our East African space. I'm just this is basically what globally, these are the issues that are being discussed. You cannot take away liability. You as the person, the employer who has introduced the platform to your employees, you cannot escape liability. You should, I mean, there's so many AI platforms on the market. The fact that you went out and solicited and even contracted some programmers to come up and design a platform for your workers, you should take responsibility. That is, I think, the first, the first party to take liability in this particular scenario should be first the employer, who has taken on the platform, who has paid, who has introduced it, who has literally forced its employees to use the platform. Then the employer will go ahead and sue the programmers of the platform. Basically, that is what the case that I've told you about, that I've shared, the information I've shared, the case I've shared, what the discussion is about. Like, yes, the employer first is responsible, and then after that, the employer, if they so wish, they can go for the programmer or whoever is behind programming the platform. And I think that literally helps us a lot in solving the mystery of, well, we have all these platforms we are using, but then the question is that now, what happens in case of an error? And an error that would greatly affect someone's life, someone's work, someone's job. I feel like, again, right now on the market, most of our AI platforms we have are really quite advanced. They're able to provide some kind of accuracy, but at the same time, you can't take away any kind of unfair biases that go on, because for one reason or the other, the programmer of that platform you could be using could be based possibly in Russia, and then you're dealing with some you're using this platform in East Africa, where the laws that govern, or the culture of that country or jurisdiction where you are is completely different from what the programmers in Russia believe to be fair or right. Yeah, so I feel that definitely the software developers or the programmers behind these AI platforms should be like secondary. The liability should get to them after the employers, and this is what the global space definitely has. This is where most of the global jurisdictions are aiming for. I would want to stop here and give my other colleagues a chance to speak, because I don't think even we have much time anymore. Thank you.
Thank you. Thank you so much, Ms. Blesvig, for that insightful presentation that raises very important questions about accountability and decision-making. Our next speaker is Dr. Vela Kedogo Kigwiru, a distinguished legal scholar, researcher, and policy expert whose work sits at the intersection of technology, competition law, artificial intelligence, data protection, and digital governance. Dr. Kigwiru holds a PhD from the Technical University of Munich, awarded with high distinction, and currently serves as a researcher fellow at the Munich School of Politics and Public Policy in Germany. Over the years, she has built an impressive body of work and advising and training institutions across Africa on digital markets, competition, regulation, and emerging technology governance, and regional frameworks, including the Africa Continental Free Trade Area. Her research and publications have received international recognition, including the prestigious 2024 Concurrence Antitrust Writing Award. Through both academia and practice, she continues to shape important conversations around regulation, innovation, and the future of digital economies in Africa. Over to you now, Dr. Kidero.
Okay, thank you so much, Lillian, for that introduction. And I'm sorry that I'm not showing my face today. It's something I love doing because I'm currently at the countryside and the internet connection is a bit shaky. So, before I start, this is one of the topics that I love and I have passion for. And we've done projects with GIZ on the regulation of gig economy, and I've shared the online course modules that we did some years back, which I built this body of knowledge. So currently, you can access the link, and then you can have a look at the modules. Module 6 on competition, the definition of digital markets is what I worked on. So if you have any questions, you can let me know. So thank you so much, Irene and Alice. You've covered most of what I had anticipated to cover, but then I'll just focus on how we can address the issue of whether gig workers fall under the employment or non-employment status. So I don't really want to do repetition. So I will share these slides with organizers so that you're able to share with all the participants. But the gig economy is a kind of market where we have 3 participants. We have the consumers who need a specific task to be done. And then we have the app-based company, which is trying to mediate between the consumers and the independent worker, who is offering their service to deliver a specific task. So the market, as Irene and Alice have talked about, it's more of flexibility and autonomy. There's diverse work roles. It's usually task-based. We have the platform that is mediating. We have variable income depending on the number of tasks a specific person wants to perform. So I was asked to talk about this blurry relationship, which really exists because, as Irene has noted out, there's control from the digital labor platform, which is not supposed to be so. Workers are supposed to just enjoy autonomy, enjoy flexibility. They can work wherever they want to work for. They should be able to multi-home, that is, work with different platforms at the same time. But when you look at this kind of relationship that we are doing, there's an issue of permanency whereby platform workers are working for a specific platform all the time, and it's not like it's their wish to work for a specific platform because of the market characteristics of this market, as Alice has pointed out, the issue of data. So because it's a data-driven kind of ecosystem, you find that most of the consumers are locked on one platform. So it becomes difficult for platform workers to move from one platform to another because they want to work with the platform that brings in more services. So there's a number of reports, a number of studies, competition commissions, employment agencies have been able to deal with to determine whether indeed when we talk about gig workers or platform workers, they are really falling under the unemployment status. But you find that this is not this the status quo, because most of them are subjected to regular working hours, so they don't have that autonomy, they don't have that flexibility, and as Irene has pointed out, the platforms can make unilateral decisions on whether to stop the workers from working on the platform and so on. So that is where the issue of blurriness comes in. So there's literally an erosion of a clear employee and an employee kind of status in this kind of relationship, and therefore we are going to look at how countries have been able to address this issue. So there's a lot of pros and cons, especially for gig workers, because one, when we look at the issue of the cons, there's unstable and unpredictable income, there are no benefits, the lack of job security, and most important, under employment law and also under competition law, they're not allowed to have collective bargaining agreements when they're seen as an employees. So, sorry. So now that we can agree that in certain instances, gig workers can be categorized as employees, we'll have to look at what is the test, what is the legal test for determining that indeed there's a work or an employment status when we look at how these gig workers work. So we've talked about the control test, which Irene has talked about extensively. So when we look at control, we are asking ourselves, does the platform set the price that is determining the working hours? Does it make unilateral decisions? So when we see some of these determinants, when you're looking at the working conditions of these gig workers, then we can be able to identify whether there's control test. So integration test, on the other hand, which is coming from the employment law, is to look at whether the worker's service is essential and is deeply embedded in the core operations of the platform. So this tries to look into the issue of whether there's permanency in this kind of relationship. And then the economic reality looks into whether, when you look at the working conditions of these workers, are they really genuine independent contractors, or are they in the same situation as employees? So this simply means that if you're defending the app platform or you are defending the gig worker, you really have to look at each relationship as it pertains in practice. So it will depend on a case-by-case basis. So I was asked to look at some of the global regulatory approaches to gig economy. So in some countries, we've seen that they have classified certain classes of gig workers as employees. So it's upon the gig workers to really provide how they work with the platforms in order to determine on a case-by-case basis if they fall under the employment definition. And then we've had judicial intervention. Irene talked about it in the UK courts, in Kenya, in South Africa. We look at it on the other slides, whereby through judicial intervention, courts have been able to reclassify certain gig workers as independent contractors or self-employed people, or also as employees. And in other situations, we've had some countries extending certain labor protection to gig workers. For example, the ability for gig workers to unionize and engage in collective bargaining, and also the ability of them to have social protection. And now we can see recently in most countries, they're moving towards the employment status presumption. So in this case, it's upon the platform to argue that and to rebut that an employment status does not exist. So these are just some of the developments we are seeing at the global level. Irene talked about Spain. We also have India, which introduced the Code on Social Security, which allows some of the gig workers to have right to social security. China has also extended labor protection like minimum wage or occupational safety to platform workers. And also we have other countries which have now using their competition law to allow the gig workers to engage in collective bargaining agreements. So I'll just talk about the European 2022 guidelines on application of competition law also as another way to extend the right to collectively bargain. You know, under employment law, gig workers are considered as undertakings, and therefore they are not allowed to engage in collective bargaining agreements because such collective agreements will be considered as cartel conduct under competition law. So, for example, under the European guidelines, the 20 guidelines, they determine that if a self-employed worker is economically dependent on a specific platform, in that they accrue more than 50% of their monthly income from one digital labor platform, then they're considered not as self-employed workers. And if they're in the same comparable situation to workers, and also if they provide their services through digital labor platform, or whether the courts at national level have reclassified them as employees, then they benefit from these guidelines. So one of the most important development at the EU level, Irene talked about, is the 2024 EU Platform Work Directive, which provides the rebuttable presumption of employment. It has identified some of the key triggers, which means that if we are going to have these specific cases in the East African region, we really have to determine, borrow from some of these key triggers of the presumption of employment. For example, according to the EU platform directive, does the platform set remuneration? Does it require specific appearance or conduct of rules, which means that does it control the workers? Does it supervise performance through algorithms? Does it organize? Does it schedule? For example, if you want to work as an Uber driver, you should just be able to wake up any time of the day and decide, let me go for this gig, because all what you're saying about the gig economy is like, this is a specific task, it's a specific gig, you can work anywhere, anyhow, and wherever you want to work. Is there algorithmic management? Is there automated decision that Alice has talked about? So how it works is that first, the EU looks at the facts of control. Are they present? If the facts of control are present, then the presumption is activated. Then it's upon the platform to rebut this presumption that by showing that the facts of control are not present. So that is exactly what, in summary, what it's all about. So when we look at the African scenario, we find that initially the workers, the gig workers, were using the courts, and in some of the cases, the African way is that you see that in most of the cases that have been before the courts have been reluctant to rule on the issue of whether we can literally have a binary relationship between self-employed workers and employees in the scenario of the gig economy. So, for example, in the case of South Africa in 2017, the Uber workers went to the Commission for Conciliation, Mediation and Arbitration to argue that they were employees under the Uber. They were employees under Uber South Africa as defined by Section 213 of the Labor Relations Act, and they were not independent actors. So the Commission argued that there was control, and when you look at the economic reality of the relationship is that Uber really exercised significant control of how the drivers worked by integrating them into their business and also setting the term of service, which favored an employment relationship. But when Uber appealed to the Labor Court focused on the issue of whether Uber South Africa and Uber Netherlands were the same institutions, and therefore it did not really look into the question of whether Uber drivers should be regarded as employees or self-employed people. And then when you come to the Kenyan scenario, when in 2021 the Uber drivers went to court and they were arguing that the steep fare cut threatened their livelihood and constituted a breach of contract, although the issue of whether they were classified as independent contractors and employees was not addressed, at least in this case, the High Court ruled that Uber Kenya and Uber Netherlands were essentially the same entity. And now we are seeing cases whereby now the associations, for example, the Transport Workers Union Association, initiating constitutional petition before the court to have a declaration of algorithmic control that exercised by Bolt and Uber to constitute an employment status. But we are yet to have this kind of so in Nigeria, the same. They have also taken a very cautious approach at their court level by literally stating that employment status does not exist. So it means that our gig workers really have to put into place a number of arguments that will literally show that indeed they are having an employment status. So the current trend now in Africa, as my previous colleagues have discussed, is that we are seeing now the countries moving away from courts, and we are seeing the issue of having a regulatory sandbox. For example, in South Africa, we have the Labor Laws Amendment Bill, which is adopting the presumption of employment as well as in the EU Platform Directive, whereby they're now expanding the definition of employee, they're having a presumption of employment, and also trying to have sectoral determination for specific sector in the gig economy. So we can see how the global developments are also influencing the local developments. So in Kenya, because also Irene has talked about it, we have the digital hailing regulations, which specifically for the hailing app market, whereby we can see what Kenya has done is to cap the platform commission at 18% in order to protect worker earnings and also to treat the relationship as one that is requiring state intervention rather than a pure arm's commercial contract. This is what we are trying to observe. And also in 2026, there's a strong legislative push to ensure that digital platforms are able to contribute to the National Security Fund. And also in Egypt, they are also moving towards the same. So as we see, very few countries in the African setup are trying to determine the legal status of gig workers, the issue of the burden of proof. In the South Africa, it's on the platform. In Egypt, it's on the worker. In Kenya, it's not really clear. And then providing them with social benefits. For example, access to social insurance in Egypt, and also the issue of whether they can be granted the right to collective bargaining. So this is just another slide of how it's happening in Africa. So in conclusion, I would say that this is a topic that lawyers should play an active role, especially in shared policy discussions on this topic, and also participate in the legislative processes that are being undertaken by the country. And also we can have a voice on this topic as the market itself is also evolving. So there's just a need for increased discussion, have policymakers, employers, platforms, and workers collaborate on how we can contribute and protect gig workers. Thank you so much.
Thank you, Dr. Vela, for that regional and comparative perspective. And our final speaker for today is Mr. Patson Arinaitwe, partner and head of the Employment and Pensions Practice at Signum Advocates in Uganda. With over 18 years of practice as both a Ugandan and UK-trained lawyer, Patson is widely recognized for his expertise in employment law, pensions, corporate governance, and labor dispute resolution across East Africa. He regularly advises boards, in-house counsel, human resource leaders, and institutions on complex workplace and regulatory matters. He also serves in key leadership role as co-chair of the Uganda Law Society Employment Law Cluster and chair of the Industrial Court Users Committee. Beyond practice, Mr. Patson is the founder and driving force behind Uganda's Labor and Employment Law Conference, which has grown into one of the region's leading platforms for labor law dialogue and professional development. A respected trainer, speaker, and governance advisor, Counsel Patson continues to play an important role in shaping employment law and workplace governance conversations within the region. Please join me in welcoming Mr. Patson Arinaitwe to speak on algorithmic surveillance and workers' rights, efficiency, privacy, and fairness.
Yeah, thank you, Lillian, and good afternoon, all. I do appreciate this platform provided to us by the East African Law Society to have this topical issue that is quite live, for us and for the workplaces, especially the clients we do serve. I hope I can keep it under 12 minutes as guided, and I do appreciate the previous panelists, my colleagues who have given a deep dive to some of the structural issues and context to the conversation. And indeed, when we talk about algorithm surveillance and workers' rights, it's not an abstract topic, but it's a live compliance and of course a litigation challenge that employers and employees across the region are navigating currently. And not just Uganda, but the East African region. And I'm hoping that in the next 12 to 15 minutes, you'd appreciate, and of course, whether you are a lawyer or an HR director, compliance officer, you probably need to have a clear answer to one question. And that question is, when algorithm makes a decision about an employee, is the employer legally protected? And is the employee as well? And the reason why this question is fundamental is the fact that modern employees now, or a modern employee, is no longer supervised only by a human manager as we knew it probably, 15, 20 years ago. So increasingly, employees now are supervised by systems. You have, dashboards now, metadata and predictive analytics. And probably at the back of our mind now, the critical question for the East African practitioners is, then how should the labor law respond, for instance, when productivity is measured by software, or when discipline is triggered by algorithm? And I think we can relate now different workplaces. Recruitment is now being filtered by AI. And even after recruitment, the employee behavior currently is continuously monitored, digitally. And I think after the COVID-19, there was so much digital penetration, and we have a lot of reliance now on AI platforms to make employment decision. I just want to start with something that happened in the workplace not far from any of us that we can relate with. So you have a logistics company operating in East Africa that deployed a performance monitoring platform for its delivery drivers. So it has system tracked GPS routes, you have delivery times, it has customer ratings that are embedded in the system, and the number of orders accepted or declined. So this system usually generated data scores for every rider across its routes. So if a driver score dropped below the threshold, and of course that threshold is set by algorithm, the system would send the driver a warning. And once you have 3 warnings as a driver, the platform removes the driver's access, automatically. That way you don't have a manager who reviewed it. No one would call the driver. The driver would simply get a notification that the account has been deactivated. Of course, from the legal perspective, now you're wondering, first of all, the rider has no idea how the score was calculated. They have no way how to challenge it on the platform. And of course, in a few documented cases, deactivation was triggered not by poor performance, but by data errors. And these errors would range from, for instance, GPS lag. You have customer ratings skewed by factors the rider could not control. Or you have delivery time calculations that did not account for the traffic. Those of you who have been in Kampala, you can see how it can be a mess. And I'm sure people in Nairobi would relate as well. So, of course, the riders lose income through a process they never saw, could not explain, and have no legal mechanism to contest. And this sounds hypothetical, but it is not, because the digital workplace now, as explained, exists today in almost every region now in the country. So that is not to say that algorithm surveillance is unlawful. It is not. But in my view, its lawfulness really depends entirely on the transparency, proportionality, accountability, and more importantly, preservation of the employee rights to understand and contest decisions made about them. And most of the platforms that are deployed in the region may fail some of those tests, not because the law does not exist, but because it is not being applied. And what is actually happening in our workplaces today, for instance, I'm sure if we did a census on the people on this platform now, you'll probably appreciate the fact that the digital workplaces now have email and communication, monitoring. You have GPS and fleet, tracking for the transportation companies. Almost you got every workplace. It has a biometric attendance systems, CCTV and facial recognitions now. You now have AI-assisted, recruitments. And in some entities like banks, telcos, or fintechs, they now have keystroke and activity tracking on the systems. And for the HR teams, I've seen quite a number now that have had to automate performance scorings. So the appraisal is no longer, brick and mortar, but now a system would have, data analytics that will actually do performance scorings. Others are doing behavior analytics and predictive HR systems, especially where you're dealing with remote or hybrid workplaces that are now with us. So it's not something that is far-fetched, but it's already here. So when we talk about the algorithmic, surveillance, probably that, 3 distinct categories, and they carry different risks. Of course, the first one, we can talk about the activity and productivity monitoring that we talked about, keystroke logging, screen capture software, email scanning, and others have real-time productivity, scoring. So almost the employee is being monitored by activity. First of all, and in most cases, without being told clearly how, the score will be generated based on the performance or what happens when it falls. And the second category is of predictive analytics. I think now most platforms sell to employers the ability to predict which employee, for instance, about to resign. I'm sure you've heard of terms like so-and-so is a flight risk. And in most cases, that is something that is predicted from score calculated from, for instance, from email, sentiments, response time, and behavior patterns. And of course, some platforms claim to flag potential misconduct before it actually occurs. But from the legal perspective, of course, the legal problem is a bit profound. Why? Because now employers are making consequential decisions based on predictions about an employee's future behavior. Of course, from the data that the employee does not know is being corrected, and I'm sure there are few employers who would have full disclosure that this data is being collected, but also analyzed by a model they have never seen, because these are back-end systems. And the third category we can talk of is, of course, the biometrical and physical surveillance. And those are the GPS tracking, biometric time and attendance, CCTV with facial recognition. And of course, and I think in every regime in East Africa, we do now have a regime dealing with data protection. And a lot of what is being done now in that space is governed by the data protection laws. I think most of the countries enacted their laws between 2019, I think with the latest being Tanzania 2022, I think the same year that Kenya made its data protection. So a lot of what is being done across the surveillance has to consider the data protection laws that are in place. But regardless of the legal risks that we can flag, we have to acknowledge why employers are doing what they are doing. And most of these reasons are legitimate. They range, first of all, from productivity improvement. Others, the banks will tell you cybersecurity and fraud prevention. Without it, it becomes difficult to do that. Others will be, regulatory compliance. When a bank is monitoring its customers' communications, it's probably meeting, regulatory obligations. When a logistics company tracks GPS routes, it's managing assets and safety on the road. And when HR teams use analytics to understand, the workforce patterns, it can lead to better management decisions. So you have operational efficiency that comes into play, customer service quality management that is important. And from the governance perspective, boards now view it as a risk management tool and as a compliance necessity, because some of the things now that need to be done, especially in the ecosystem that is regulated, requires AI assisted. Or a productivity matrix now. You can imagine now handling performance management in a manual way, when you're dealing with over 2,000 employees. And of course, also the board would look at it as an ESG or governance issue. So before we do the criticism or the legal risks that come with it, we've got to appreciate from the governance point of view why it would be a necessity for most of the employers. But of course, the pivotal question relates now to the legitimate purpose. And of course, sometimes even when you have a legitimate purpose, it doesn't make every monitoring practice automatically lawful. And of course, it has to be subjected to different legal tests depending on the jurisdiction. And the question for us now is whether most current deployments of these AI tools in the region have clear framework, especially where employee rights are protected. And you have that, while we've expressed the need, the business interest to protect, you now have the emerging legal tensions. Efficiency, you have on one hand, you have efficiency that is required, accountability, compliance, maybe performance management, and protection of assets. Now, against competing employee rights of privacy, you have dignity, you have fair treatment that is expected, freedom from discrimination, that sometimes most of the algorithm tools tend to have certain inbuilt biases. And of course, procedure fairness. Most of our legislation now require that before you exit somebody, you must give them both substantive and procedure fairness. And the question is, when you have the AI embedded surveillance that we utilize or rely on to make a definitive decision on somebody's career, would you have complied with procedure fairness that is expected? So this is the tension that is at the heart of everything when we're dealing with surveillance. And the question is not really which side wins. It's how you build a system that genuinely serves the employer interest, and while genuinely, of course, protecting employee rights. And that tension has to be balanced quite well. And those of you on the platform who represent employers, you realize that most employers you advise are not trying to violate employee rights. Far from it. They deploy these tools without thinking through the legal ecosystem or the legal ramifications. And of course, they only look at the business case of how it is going to solve business problems. And now when they deploy them, they now carry risks they did not know they had. And it's our role to advise accordingly. And as we know prior from the ILO standards and most of the labor laws across the region, most employment laws have been designed towards balancing the employer authority and employee protection. What is new is that the technology now creates imbalance the existing law was not designed to address. You have algorithm that is not going to call in sick for sick leave. It won't have a bad day in office. And of course, it does not appear in court to explain its reason. Unfortunately, it is being used by an employer who will have to address some of those issues, especially if you have to defend a decision when you've exited someone. So the task of every practitioner working in this space, and you don't have to be a tech lawyer, is really to ensure that the rights on the right side of that are not simply washed away because a decision maker has been replaced by a software. So among the tensions we really have to deal with, of course, is the data protection laws that I've talked about, because the surveillance comes with a lot of data harvesting. So when we're dealing with AI or algorithm, especially from the data protection point of view, we already have a framework. You have the Data Protection Act of Kenya, of Uganda, as well as of Tanzania. I think even Rwanda has a Data Protection and Privacy Law of 2021. So we probably do not need new legislation to govern algorithm surveillance in the region. So the legal framework, at least partly, is already in existence. Probably what is missing is the enforcement, but also to focus more in terms of the blend between the technology that is being deployed and what the current legal regime speaks about in as far as the employee rights are concerned. And you will note that a lot what is required relates, for instance, to consent. Why? Because again, like we've explained, the traditional employment assumes human supervision, identifiable decision makers, visible disciplinary reasoning, as well as explainable performance assessments. So what algorithm creates is really an opaque decision-making process. You have automated recommendations right from the performance point of view. You will have hidden biases. And I think Amazon faced the same when they developed a recruitment AI that later realized that was actually removing women. So you have limited accountability. So what is critical now is to see within the process, how is consent embedded? Because consent in an employment relationship, first of all, is not free. And it cannot apply generally, especially from data protection point of view. You just can't have a blanket consent in employment contract that will apply broadly regardless of what you're bringing on board. And that is something that needs to be carefully designed within the employment relationship. Then, of course, you have another element which has, purpose limitation, especially the data protection laws across the region. Most of them require that states that data collected for one purpose cannot be repurposed for another. If, for instance, you are collecting data for medical or to make an insurance case, medical insurance, then you can't use it for something else. Or if you deploy a GPS tracker so your logistics team can allocate vehicles efficiently, can you use it now to locate for an employee who went for lunch or for something else? So the repurposing in some jurisdictions can be unlawful. But also the biometric data, at least for the Ugandan perspective, is designated as sensitive personal data that requires heightened justification. And I know, for instance, in Uganda, many employers are running biometric attendance systems right now without documented lawfulness assessment. Of course, that's not a future risk. It's a current, non-compliancy concern. So most of the HR across, for instance, border, whether in Kenya or even in Europe, are now using a lot of personal data. They're using cloud HR platforms. The Ugandan HR data could be stored in Europe, in US, and yet you have data protection laws that even prohibit transferring personal data to jurisdiction without adequate protection requirement assessment that has to be, done. And from the decision-making process or from the discipline management point of view, you can imagine where now you have to consider the surveillance, the algorithm generated information, how that data fits within the lawful process as we know it under the disciplinary procedures and processes. Can you have data that has been collected by somebody who is not an investigator? The employee cannot defend himself against the system, but probably you are relying on the data as being accurate. So how are you going to use it within the disciplinary process? Of course, the disciplinary process becomes vulnerable where evidence is AI generated but can't even be explained, or employees cannot challenge the methods used. What that means that the decision will rely on inaccurate or biased data that the employee cannot challenge in a disciplinary hearing process. And that is something that needs to be of concern to every employer and employee. And the critical question for us is, can an employee fairly defend themselves against a decision they do not understand? What would the East African labor courts like to ask? Was the process transparent? Was the employee informed? Is the technology relied on reliable? And more importantly, was there human oversight? Because even most of the employment laws we have really still consider the employee oversight that is expected. And the last bit is, of course, the biases and discrimination risks that have been discussed, over time, considering the fact that these AI surveillances or systems are not neutral, as we may want, as most developers would want us to believe. And sometimes the discrimination is unintentional, but it's relying on history, it's relying on patterns based on gender, age, socioeconomic patterns that can influence the decision. So for the East African states and particular employers, imported AI systems are often trained on non-African data sets. They may not reflect, for instance, the local workplace realities in deep in upcountry in Uganda. You have linguistic diversity, you have cultural context or informal work structures that require probably a human touch before we can understand. And of course, there are those prohibited discrimination grounds under our employment laws. So we have to test most of these AI tools to see whether they would pass the test provided for under the law, and whether the law needs to change to ensure that it reflects what is happening. And of course, what is important is the fact that the surveillance.
Sorry, Council Patson. I
Yes.
see we are running out of time, so I'll give you 2 minutes so that we can just wrap up.
No problem. I'm completing. Thank you. Yeah. So the underlying idea is the fact that we have to look at the systems, the surveillance tools and platforms within the context of legal risks, and ensure that the fundamentals of employee rights, they are protected, but also without negating the fact that some of these tools are there to protect employers' business interests, but they're not diametrically opposed to each other. They can actually work hand in hand as long as we monitor what is being rolled out and we test it against the employee rights that need to be protected jealously. I thank you.
Thank you. Thank you so much, Council Patson, and to all the panelists for those very rich and thought-provoking contribution. What we are clearly seeing from the discussions that we've had is a shift in 3 core areas: how control is exercised in the workplace, how accountability is allocated in a algorithm-driven system, and how employment relationships are being redefined in the gig economy. I know that we have several questions in the chat box, and also 2 of the participants have raised their hands. So this is how we will do it. I will take 2 questions from the participants who have raised their hand. Then thereafter, I'll go to the chat box and come back again to the participants. And I'll start with Ms. Doreen Ojienda. If you could unmute yourself and then just proceed to ask your question and be specific on who the question is addressed to. Brina, you'll help me if there's need to unmute the participant. Yes, you can proceed, Ms. Ojienda. Ms. Ojienda? Okay, as we're still waiting for Ms. Ojienda to unmute, Kibanya Nguru, you can proceed with your question. Please unmute. Brina, or the issue is with us. If you're able to assist with unmuting them.
Lillian,
Okay.
there are some questions in the chat.
Okay, I think we can take those questions as maybe we wait for Brina and Kibanya to sort that. So the first question, Alice, since you're there, you'll take the first question. And the question is to you: what happens to the worker who signs up work online, like a freelance or a crowd worker, and there's no employment contract or employer to be held liable. They sign up and they work for this organization, not resident based in the country, but some algorithmic boss. How can they seek remedy? Who do they sue and in which court?
Thank you, Lillian. This is turning out actually to be one of the hardest legal questions in the digital labor economy right now that we've been exposed to, and that has clearly shows the gap between traditional labor and platform-based work. Unfortunately, despite all the negatives that come with these platforms, I would also want to say you have to empathize with both parties. I think Patson tried to talk about it, because even the employer, the benefits for the employer, there are actually also benefits for the employee in terms of how these platforms work. Very efficient. They've been able to curb and get rid of so many of the nuisances that we've experienced in a long time dealing with human labor. But at the same time, again, the unfairness is also, glaring in our eyes. So we pretty much cannot avoid this. And also, we need to put into consideration that there are benefits as employers when you're signing up for this kind of platforms. We need to understand the global employment spaces now we operate in. For example, the people who work for Uber, you can't, it's just never now all about your jurisdiction. Like, for example, in Kenya, Patson was talking about this, the cultural context of employer-employee relationship is completely different from the relationship in Russia. In Africa, if you have a wedding or your aunt's wedding or something, someone has you've had an issue within the family, your employer, for one reason or the other, is very empathetic and is able to let you go. Now here you are as an Uber guy, and something has happened in your family, and you feel like you need actually to go and attend. Of course, the system is going to boot you. There is no explanation at all, because to them, in a global space, you understand, you have signed up a contract to terms and conditions that govern global spaces, and you're benefiting from them. In many cases, you're getting like an international salary. So there are so many pros and cons. But anyway, the most important thing now is, who do you actually sue in this particular case? There are so many layers. But what the fact that within East Africa, we don't have any like specific laws. I never actually want to justify the fact that because we don't have specific laws, then we don't have any laws at all. We have laws definitely that govern digital spaces. And I mentioned earlier, we have very strong data protection regulations within the East African community, and also with the AOE, African Union framework. So we can definitely use those regulations right now. But on a global stage, what they usually do is, one, you look at the digital platform itself, who is benefiting from it? Who is benefiting from the labor? There are usually multiple entities in there. So who do you sue? You go, for example, if it's Uber, sometimes actually they don't even have offices locally, but they usually have an intermediary. They usually have like someone, like a personnel or someone who is registered in the country. That is the person you could be one of the defendants of the company. And you need to know, when you go, for example, the labor courts, when you're in a dispute, they need to know who sets the rates, who controls the access to the work, who disciplines the workers. And again, unfortunately, our courts, I think, have not yet gotten to this stage of having these, analytical systems where they're able to actually analyze these platforms and understand who is behind them. You cannot say that I signed up to a platform and I don't know who is my employer. You also have to take an initiative to understand and read those contracts. Some of these pages, platforms, they have a lot of information. There's so many hidden terms and conditions here and there. You need to read, to do the work before actually, us as lawyers, before the client, when the client comes to you, ask them to read, to do the work and read, get down and sit down and read. Lastly is about the jurisdiction. So which court has jurisdiction? Most of these crowd work platforms, you'll find the platform is incorporated in the United States, or the worker is in Uganda or Kenya or Tanzania, and the platform is incorporated in the United States, Netherlands, Singapore, and you know, but at the same time, you're benefiting from this, right? So what do you, and also in case now you have a dispute, you have to go to your local labor court. Now through that local labor court, that's when you are able to actually bring in all these defendants, meaning the person who is benefiting from the work, the developer of the platform, so that whatever decision is made by court, it trickles down to, you know, with the three-layered defendants, meaning your employer first, the person who literally reached out to you and said, sign up to this, or whatever system you use, someone should have either their representative locally or someone, that person should be at least the first defendant. Then you have the second defendant, third defendant. I don't think it can only be now anymore, just one defendant. You need to do the work, understand the platform you're working with, and also, of course, us as the lawyers, we need to do the work. So another thing I find, which is also very common, is that most of these contracts they require, they have provisions which mandate, require what? Mandatory arbitration clauses, or the laws, the contract is governed by foreign laws. In many cases, because we are excited about that job, so you just sign up. Unfortunately, your hands get tied, right? So you need to read and do the work before you sign up. That, am I really actually ready to work in this global space? Because many of us, you get all these global benefits, but then you don't want to appreciate that, you know, that you don't want to appreciate the benefits and then complain, you know, locally. So right now, the global spaces have to take care of all cultures. They can't say, oh, you know, Kenyans, when this happens, this is your culture, we'll understand you. No way. I feel like the way, when you're working in these global platforms or global spaces, you have to definitely understand the global culture. Yeah, that's it, pretty much what I can say. But I feel in terms of specific laws and regulations, all our Employment Act or regulations currently can be able to govern or regulate this this space. Of course, our constitutional our constitutions, like for example in Uganda, it's very clear on rights to fair labor practices. Data protection laws are very clear on, the person has given that in detail. So really, there's no absence of law, literally. I would say there's no specific law to govern the space, the digital working space, but at the same time, there are laws that we can actually use to be able to represent our clients ably in this space. Thank you.
Thank you. Ms. Kashindi, there's a question from Grace Sitati. What is the way forward for the Oversight Lab petitioners now that the Business Law Amendment Bill is now in force?
Thank you, Grace, and I hope it's a Grace study that I know if it's you. Hi, Grace. Yeah. So for that question, I don't know, Grace, whether you're talking about the Business Laws Amendment Bill that was passed by the National Assembly. The one that was the subject of this petition was actually a Senate bill, which the last time I checked, when the decision was passed in May, had not yet been passed into law. It is still pending consideration in the National Assembly, having been initiated by the Senate, and it's pending concurrence or consideration at the National Assembly. It's the one that has a provision. The main issue that was being challenged, one of the issues that was being challenged was the contention by the petitioners that there's a proposal that there's a proposal in the bill to shield tech companies or big players in the global space who are in an outsourcing arrangement from taking liability when such things that we're talking about happen. So that's the provision that was one of the provisions that was in issue, and that bill is yet to be passed into law. Lilian, if you'd allow me, there's a nuance that I would like to add from a Kenyan law perspective from that question that Alice answered in 30 seconds. Is that okay?
Yeah, please proceed.
Okay. Yes. So from on where to sue, what to sue, jurisdiction, and so on and so forth, there's been cases that are passed through our legal system, the Kenyan legal system, and particularly the Meta cases that went to the Court of Appeal. And one of the questions that the court was dealing with was whether or not these foreign entities would actually be subject to the jurisdiction in our local setting, and the Court of Appeal said yes. So that can be used as a guidance in as far as, of course, Kenyan law is concerned. But even before the Meta case, I know from general labor law perspective, where I've seen cases where the courts have said, when it comes to labor law, notwithstanding the fact that an employment contract would have a foreign law clause or a foreign law jurisdiction forum, so to speak, when it comes to labor law, because of an international principle of conflict of law, I think it's called territoriality. Forgive my Kenyan influence in my pronunciation, but it's territoriality or lex loci something. There's a Latin maxim to it that says, despite foreign law clauses or foreign law jurisdiction forum in employment contract, the law that should apply should be the law of the country where performance of the employment relationship happens. I'm just trying to put it in simple terms. And if you'd like me to share a case or two from not a digital platform perspective, but general labor law perspective, I'm happy to share. I just wanted to add that nuance in as far as jurisdiction is concerned. But I think the last thing that I could add is that I think it really depends on what the cause of action is. If you're pursuing it from a labor law perspective, you may have to then look at is there an employment relationship, or is there an issue that you are raising, like what happened in the Meta case? It was an issue of occupational safety and health from a digital platform perspective, and therefore the court said they have jurisdiction. But if you're raising an issue as to whether or not, let's say Uber is an employer, or to enforce employment, labor and labor relation rights, then you see, because our law has not yet changed to then say Uber should be an employer in that setting, though there are proposals to create an intermediate classification, as I said, you would not be able to enforce that kind of rights, but you can be able to enforce other, causes of action. For example, under one NTSA, it's called National Transport and Safety Authority. There are regulations that have been passed under that act that regulate ride hailing to a certain extent. So if you'd want to maybe enforce those provisions from a regulatory perspective, not necessarily from a labor law perspective, you could do that. So in essence, what I'm just trying to say is that it depends on your cause of action, which will then inform what law you are actually enforcing. But if you're also now on the platform, because I think we are speaking to both platforms and platform workers or employers and employees. If you're in the platform, then you're able to defend yourself as to whether you that's a law that applies to you. That's what I wanted to add, Lilian. Thank you.
Thank you. Ms. Kashindu, you're still on your feet. Maybe you can tackle this question from Ms. I think Puva Jane. I hope I pronounced that right. If any accident happens at the workplace, then who is responsible for it in a developing economy where earnings are more important for gig workers than safety? Then thereafter, I'll address a question to Patson.
Okay, I think I've answered a bit of that question when I just answered a short while ago. I especially if you're talking about digital gig economy, the way we understand it, for example, using ride hailing. If a rider or a driver hurts themselves, who would be responsible for, I think that's what you're asking, from an OSH perspective. Of course, now that boils down to which law are you enforcing? If you're enforcing it from an an employment and labor law perspective, the employer and employee relationship does not exist in that context, at least in our current legal framework, and therefore you may not be able to enforce it from a labor law perspective. And therefore, because now you see the current framework is that these platform workers are recognized as independent contractors. And from an independent contractor's perspective, you are, as an independent contractor, you are you're responsible for, your own, what can I say, safety and health, so to speak. But having said that, I know there are many countries and I know there are many legislation that both I and my learned friends highlighted, where that is shifting such that there is a categorization or a requirement under the law to then provide core minimum rights to these platform workers, and that in some countries actually extends to OSH in certain ways, different structures, different ways. Countries are looking at it in different ways, and therefore there are many conversations that are going towards that end. But as of now, I'm talking from a Kenyan law perspective. It will really depend on what is your cause of action, and if you're doing it from a labor law perspective, the employer-employee relationship has not been created in the platform economy. We're still working on an independent contractor model, though that may change maybe in the near future. Yeah, thank you.
Thank you, Ms. Kashindi. Senior Patson, how can advocates prepare their clients for the vast AI transitions from conventional employment to consultancy and gig work? What does the future of employment regulation within East Africa look like in 5 years? That's a question from Yvonne.
Yeah, thank you, Lydian and Yvonne for that question. Very progressive and of our time. And maybe if I start with the last segment of the question, I think there's an ardent principle that law follows commerce. It's not commerce following the law. And what we see currently with accelerated integration, it is a matter of time that certain rules will be aligned. I'm privy to the fact that currently there is a labor law judges forum for East Africa that is harmonizing a lot of principles in as far as jurisprudence is concerned. For those of you from Uganda, you know that almost our industrial court decisions, when you read almost 1 out of 4 decisions, actually 3 out of 4, they have heavily relied on the jurisprudence in Kenya. Even when there's a bit of divergence on the text of the employment laws, there's a move towards harmonization. So, and it's because of the need. Most of the companies headquartered in Kenya doing business in Uganda, doing business in Rwanda and Tanzania. And I think it's a question of time that the legislature of different countries and hopefully the East African community moves towards harmonization, because commerce is harmonized, without the strict rigors of the law. And courts are actually aligned to such. So hopefully that we'll see more harmonization, although, we have politics that are holding out the accelerated program. But I see a gradual process towards unified principles, at least, even if there'll be specific nuances that apply different jurisdictions. So while we may not see legislation, and it's the hope that it can come, we'll see more harmonized jurisprudence as we see. I think Zambia, Mauritius have seen a lot of picking of cases from East Africa. For me, that's a very good thing on what is happening, even when our statutes are not the same. I didn't pick the first part of that question. If you could relay again.
How can advocates prepare their clients for the vast AI transitions from conventional employment to consultancy and gig work?
Yes, so the preparation, I think it's in a phased manner. One, for me, discussions as these are very helpful. And as practitioners, we really need to get ahead of the curve in not only getting to understand our role in practice, but what the businesses and the workplaces are. And I think you know that the workplaces are ahead of the statutes. Unfortunately, most of the lawyers, our advice seems to be more statute-based or academic than what is happening in the workplace. And I think the preparation of the AI requires first to understand what is happening in workplaces when we say performance has moved from the brick and mortar to data analytics to understanding productivity on a daily that feeds into weekly and monthly performance. Then we will advise from the perspective of if you say poor performance, you are put under the PIP, do we have the necessary tools? So as lawyers, I think the workplaces are probably ahead of the times. We just need to prepare ourselves to bridge the gap, because you realize that then your advice might be detached from the realities, and yet the law can actually be harmonized to answer to the prevailing AI-related legal risks. I think 2 months ago, I was arguing a case in our labor courts relating to data analytics and performance management that was AI administered, and the courts were not happy that there was no human being involved. But this is somebody who was working remotely. 70% of their work was remote. They would only come to office just to check in, as the HR people call it. So there's a need to get to understand how businesses operate, what are the progressions in as far as AI is concerned, what systems are being rolled out, and then prepare ourselves, especially on the legal risks, the compliance checklist, and stress test them against the business needs. Like I said, business will continue even as we have discussions on platform. These are the requirements of the modern workplace, and they are not going to go back to ready-mixed concrete case of defining employment relationship over 50 years ago. So there has to be an alignment with the current trends. And as lawyers, we need to move towards the developments that are happening at the workplace. And maybe if we can influence policy or statutory change, the better. Maybe we're not senators, but I think what is critical is to utilize what is prevailing in terms of the law. And I know our courts within the member states are more happy and flexible to interpret the law within the circumstances, as long as the bare minimum protections under the law are not compromised. So the readiness is getting to understand the marketplace, the risk mapping of what are the new emerging risks and how are they answered within the current employment law regime. Yeah. Back to you, Lillian.
Thank you. Brina, I note we have 5 minutes. I hope you can add us between 5 to 10 minutes so that we can just tackle all the few questions remaining. I hope that's okay. Thank you so much. I see there's a question from Ide Louma, which is to all the panelists, and I will give each panelist at least 1 minute to answer that question. My question can be answered by all the panelists. With the gig economy setting the stage, is the boss of the future inevitably a platform? If so, how can we structure partnership between human oversight and platform efficiency that prevents the loss of human mentorship and professional development in an automated world? I'll start with Council Alice, then I'll go to Madam Kashindi, and then Council Patso. Ms. Plavik, you are muted. Okay, maybe Madam Kashindi, you can go ahead as she tries to.
Thank you. Thank you. Thank you, Idel, and good to see you here, Idel. So I've seen your question, and I think the answer to that is yes, we are looking at the boss of the future. Maybe it's actually the boss of the current workspaces that we're looking at. But I get your question. Yes, what do we do? Should we develop structures for partnerships with between human oversight and platform efficiency? And I would answer your question to say, I think the trajectory of the current reforms are such that our parliaments or legal reform is not intending to completely remove human beings. Actually, there are many requirements that are coming up that requiring human in the loop. I think that's the description, right? Human in the loop. The description being, or the requirement being, that there should be no automated decision making that do not have human intervention. So while we may be forward looking and we're looking for structures where we're ensuring that there's platform efficiency, this AI boss, or this algorithmic management is not replacing human beings, and for good reason, because AI is artificial, technology is artificial. Human beings have much more attributes that technology does not have, and therefore, even in our own Kenyan setting, the AI policy, but also the discussions about amending about 23 laws that are affected by all these developments. One of the proposal is to actually introduce provisions on regulating algorithmic management, specifically ensuring that there is human in the loop in as far as employment and labor space is concerned, so that we're not just looking at from a data protection perspective. I'm sure Alice and even Patson and Vela talked about it, that our current data protection laws have the requirement for human intervention in automated decision making, but there's actually a move or a proposal to then go a little further, specifically to provide for human intervention even in an employment space. And therefore, while that partnership for efficiency is important, it's still good to look back to actually see that the trend and the development is to still ensure that there's human intervention, human management, so to speak, so that there's no fully automated decision making without a human being having a say. Thank you.
Thank you. Councillor Patson, would you want to add your voice to that?
Yes, that's an interesting question, and I think there are two perspectives to it. I believe that there's some workspaces where AI will be the boss, and possibly those workspaces, AI is replacing human being completely, because certain tasks will be automated. The input and the output is AI based. And I think we are getting there. But in spaces where there's still need for human mentorship and human input, then AI will not be the boss. I think there was a discussion, for instance, AI does not have empathy. AI does not have, will not have feelings over certain issues. AI may not explain itself to court, maybe later. So with that space, you still need human mentorship, exercise of human attributes, and therefore we can't see platform replacing human beings. And maybe those are the spaces where the human attributes are still needed. But we know that there are some spaces that are already happening where the output ordinarily that should be the input that should be employee and the output that should be supervision by the manager are already taken by AI. So you can say fully you have an AI employee and AI boss. But there are those where there has to be a blend, and the human manager must account for the product, must account for the performance, must account for the output, and therefore performance is still an issue for a performance metrics for a mentor or for a manager. So it's a move that we think that certain jobs fully will be integrated into AI, and we can only talk about platform bosses. But also we know that legislation is pushing back, especially because of the bare minimum protection levels that I think Irene has also talked about, to the extent that even when the marketplace is pushing towards full automation and no human interface, we're likely to see legislation because of the bare minimum or ILO standards of decent work, that there will be pushback from the regulators or parliament to ensure that human decency is still obtaining at workplace. Yeah. Thank you.
Thank you. Ms. Blesvig, I see you back. You want to
Yes.
take?
Sorry, I kept on pressing the buttons and somehow wasn't succeeding. Sorry about that. I feel like the question has been answered by, I guess, the last people. I could just add the aspect of, actually, the main topic is, can AI, who is the boss, right? Can AI actually be the boss? Functionally, yes, but legally and ethically, no. Because there's no country that recognizes AI, can recognize AI legally. You can't sue, you know. You sue the person behind the program, but not the system itself, right? And right now, of course, we all acknowledge that AI is already in the modern workplace because of how it's able to assign tasks and monitor productivity, schedule shifts, and all that. So yes, it's basically creating like a supervisory role, but then we need to understand who does it, that supervisory role, who does it benefit? That's the question. You can't just say, oh, there's a machine there that is doing all this amazing work. Who is it benefiting? That is the person who should be sued. And there should be no ifs or buts about it, because you cannot sue AI directly. Which court would you go to and say, Claude versus, I mean, you of course, Claude is a company, and then you have to understand now who is behind Claude, who is benefiting when these algorithms operate and perform these kind of tasks and attain this kind of results. If you're the one, then yeah, you're the one supposed to answer all these questions. So can AI be will AI be our boss? And how do we align actually the human interaction? I think the human interaction this has also been discussed thoroughly. We still need the human interaction, because on ground, you need to understand who you're actually hiring. Is this person even capable of performing the duties you would want them to perform? Of course, there are some duties and tasks right now, like virtual assistants all over. You could be anywhere in the world and have a virtual assistant anywhere in the world. I feel like there's some there's some tasks where you don't need human interaction, but at the same time, there are also many tasks where you need the human interaction, human oversight, explanation, transparency, the human being, you know, to interpret what exactly the company's objectives. So I feel like we still need a lot of human interaction, and also, by the way, for this AI to advance and to, I guess, to develop and, you know, do all the magic it does, it still needs human interaction. It still needs a human being to advance it, or to reduce its productivity. So my answer is, legally, no, we can't have AI as a boss.
Thank you. Thank you so much, Council. I see there's a question from Dear Benen. I believe that's from South Sudan, and I think it's a question that had been answered by Madame Blesvig. This is a question on who are the parties to sue. Do you sue all the parties involved? I think that one we had tackled. And then there is also a request from Kibanya Nguru. Is it possible to have a comparative analysis of the different employment laws within East African community on the topic specifically and generally? I am aware that some of the presenters had submitted on some comparative analysis in different jurisdictions, but that's a really valid request that I think the committee will definitely consider, and also a challenge and a request to our panelists today so that we may have another conversation along that line. So we've taken note of that, Mr. Kibanya. And then there's a question from Pauline Kawira about jurisdiction. A country like Kenya recently signed a bill excluding the French troops from liabilities. What happens when you find these acts are inconsistent with some Bill of Rights? I don't know. Madam Kashindi, would you want to take that? That touches on your country.
Lillian, did you freeze or is it me? Can I be heard?
Sorry, did you hear me? Or do I repeat?
Why was it addressed to me? Lillian?
It's a question touching on Kenya, so
Sorry,
perhaps you can assist.
my network was tinkering. Is the one for Pauline? Was it addressed to me?
Yes, Pauline
Okay.
Kawira.
Okay, fine. I don't know why, Pauline, whether you listened to the answer that I gave earlier. I don't know whether it's related to that because I'm not so sure of which legislation you're specifically talking about from the French troops. But if you're talking about the Senate bill that was accused of shielding some foreign entities of liability, that is not yet passed into law. So maybe you could clarify which law you're talking about. But generally, of course, if that happens, we know how robust our Bill of Rights is. The chapter in the Constitution, if there's any belief that there is a violation or threatened violation of any of the rights of the Bill of Rights, of course, Article 21, 20, 21, 22, 23 of our Constitution would enable any party who'd like to challenge this legislation go to court. So that's, but Pauline, you could just text me which bill you're talking about exactly, then you could pick it up from there. But I think the earlier answer I gave could also help in that case.
Thank you. Thank you so much. Pauline, you've had request from council, and I hope that you'll be able to text her and she'll be able to address you. Now, allow me just to take one last.
Lillian, if I may write on that question as well.
Yes.
I get a sense that Pauline's question also can spread across some of the immunity-related legislations. And I know, especially from the diplomatic privileges point of view, that certain jurisdictions actually grant immunity from suit over nations of another country. And it comes really from the diplomatic privileges point of view. Now, the question whether international law would allow, or the national constitution would allow expanding such diplomatic privileges to entities or bodies that do not have such immunity. I'm aware, I think since the CONCOP days, I think that's there's even a Kenyan case relating to diplomatic immunity. We've seen in Uganda where you can barely sue an embassy on employment-related matters, even if they touch equivalent of Bill of Rights. Because what most of these diplomatic immunity legislations provide is actually to insulate certain diplomats from, so it's a process issue regardless of the rights, embedded. And we've seen that in many jurisdictions. So other than where you have diplomatic immunity, I can't see how an act of parliament would insulate another person or entity unless they first clothe them with that diplomatic privileges and immunities.
Okay, thank you. And the last question, Council Patson, you're on your feet. Are you aware of any attempts by the countries within East African community to harmonize the employment law as to minimize possible confusion due to the countries having different laws? I believe this will go a long way to encouraging employment opportunities within the region. That's from Kibanya Nguru.
Yeah, I had touched that briefly, but I think it's not from the legislation point of view. But I know there's a lot of talking by the labor law judges within East Africa. They have already created a forum to harmonize jurisprudence. So I think going forward, we are likely to see that harmonization. And there's also a push to have or hopefully out of such conversations, to have an East African Labor Practitioners Forum. And that's how we can push towards policy reforms. Other than that, it's a territorial issue, especially employment is almost like IP as well. They tend to take perspective of territory. But really, and if I may add, these are some of the conversations that we're going to have on 28th and 29th, as we have the Labor and Employment Law Conference that is targeting the East African practitioners to broaden the conversation on employment-related issues between HR, business community, and lawyers. And I thought I should add that. Thank you.
Yes, in fact, I was going to request you as you give your parting shot, because I know Gabriel is not here, and there have been questions about that particular conference, so that you can also address. I saw there was a question on how can you attend this conference? Are there any requirements? Is it something you can address in less than a minute?
Absolutely. So this conference, which is in its 5th edition, has been happening in Uganda since 2018. Attracting over 300 delegates with business community, HR practitioners, labor lawyers, labor judges, and practitioners to discuss basically employment law and its evolution. Cross-cutting issues that are happening are discussed with the intersection of those different practitioners. And for the last 8 years, it's been one of the most successful conferences we've had in Uganda. And for this year, really, it's being broadened towards East Africa. Reason being, we've seen a lot of companies in Kenya, in Tanzania, in Rwanda are setting up in Uganda, are already set up. And there's a dire need to have conversations that can be able to help businesses do business better within the region than working in silos. So part of what this conference is geared towards is really to bridge that gap, at least from the judicial and practitioners' point of view. Would be happy to welcome you in Kampala. It's roughly $250 attendance, organized by the East African Law Society, Signum Advocates, as well as the Human Resource Managers Association of Uganda. And soon we'll have the institute, the HR Institute from Kenya, to see that the discussions are balanced from users or the people who actually interface with human capital. There's a lot of strategic discussions at board level, the courtroom, and reforms that are happening within our region. And we'll be happy to have the principal judge, the head of the Labor Relations Court in Kenya, as our keynote speaker. That already speaks to the transition towards nucleus discussions to broader East African matters. Yeah, so even the secretary, including Lillian herself, she's a contact person for this in case you need further details. Yeah. Thank you.
Thank you. Thank you, Council, for shedding more light on that. I know also Brainerd shared more information in the chat box, and I know the secretariats will be sending more information to the members on that for those who will be interested in joining our colleagues in Uganda for that particular conference. Now, a parting shot, 2 minutes each. I will start with Ms. Blesvig, then Ms. Irene Kashindi. Apologies from Dr. Vela, who had to step out a little bit. Yes, Ms. Alice, you can proceed with your parting shot.
I feel like what people really want to know is what exactly happens in case you need a party. Actually, people want to know which is the party that I should take to court or who I should sue. But I think before we get to that, it's important to appreciate both parties, what the AI is doing, as in appreciate it. Actually, the confusion it has gotten, gotten away with in terms of our performance, the delays, the high cost. So there's so many benefits actually to it. But then, like I mentioned earlier, we cannot ignore the unfairness and all the unfair biases it comes with. What I always share with our audiences, in an African region, is we're always very quick to say these biases are stem from cultures which are not, our cultures, right? And so we end up being like victims to platforms where they are not programmed for us, right? They're not programmed for our spaces. They're not programmed, to cater for all the differences we have in the African jurisdictions. But the simple answer there is then we have to support our innovation spaces where we have more of these kind of programs that are programmed for the African market, to understand the African culture. You can't blame someone whose experience is, has a certain lens of the way they look at things, what employment should be, what the kind of laws and regulations or workspace should be, and they're based in Switzerland. That is that's how they view life. That is their lens. You can't blame them. They've come up with their program. And then you've bought it or you've subscribed to it, and now you're blaming them for not seeing you. I think the best thing would be for us as Africans to kind of support, definitely. This, of course, goes to governments or even us, the private sector, to come up with innovations that can definitely support our African culture or even just the differences. But all in all, I go back to answering the question, who is the boss here? It's everyday use, everyday in terms of performance, functionality, and who you report to. AI can definitely take charge. But who is responsible legally is the person who benefits from the use of the AI. That's it.
Thank you. Ms. Kashindi?
Thank you so much, Lillian. I wish there was more time, or I wish we had more time, because we also have to move on to a couple of other things. But it's a very enlightening discussion. We had so much to say, but maybe I would just end by actually saying that this is a very evolving space. You can just see from different jurisdictions what is happening, what Patson talking about, what Alice, what Vela talked about, what I highlighted from a Kenyan law perspective, but also from sort of like a global perspective. And some of the questions that we didn't have time to go back into, like, for example, there was someone who was asking about vicarious liability in a digital space. These are things that, you would never really have thought about it from the way we understood vicarious liability in LLB, year one. You would never really have understood vicarious liability from a digital space. But we're increasingly seeing that from the day-to-day work that we do. I'm currently handling a case which is more or less similar to what that gentleman was asking, is that how do you determine vicarious liability if an employee has gone on a floric of his own in the digital workspace? and those are things that we never really thought about 10, 15 years ago, and it's really an evolving space. The last question they're seeing from Alan saying, AI is actually coming to replace jobs. I'm trying to answer the questions, Lillian, you can see as I end as my parting shot. Yes, but I end in 30 seconds or so. Alan is saying, AI is coming to replace jobs. To a certain extent, yes. And from an ILO perspective, from ILO statistics, I think there's a report that was done sometime last year in May. The projection then was that about 25% or more globally, that is, are jobs that have been impacted, but 75% may or may not be impacted, and there's more talk of augmenting human input in as far as AI is concerned. So those are the conversations that we're still talking about. But I end with more or less similar to what Alice was saying, is that yes, who is the boss? I would say for me, it's not straightforward because of all these complexities, and it depends on what you're looking at. You could say, yes, the boss is the person who exercises control, but the person who is exercising control is an algorithm on the other end. But the boss as well depends on what is the legal framework, because as I said, we are looking, as Alice, and I totally agree with what Alice is saying, is that we are looking at the digital workers or platform workers on the other hand, but we're also looking at what the platforms are also saying. They are saying, for example, that digital or platform workers have flexibilities, they can multi-home, which is not something that you can do. I cannot work for MMK today and I'm working for another entity tomorrow or the same day. That in a traditional setting, that flexibility that now exists in a platform setting is not something that we were used to previously. So how do you then determine control on the other hand, but also flexibility that the platform workers are have? How do you marry the two? How do you balance between the two? And should you even be talking about who is the boss, or should you be talking about how do we balance rights and responsibilities so that we do not stifle innovation, but at the same time we also do not we also ensure that the platform workers or the digital workers have core rights, and their rights as human beings are actually taken care of. So I think for me, it calls for a proper striking of balance between these two entities, these two parties, if I would call them that way, if we are to really get, I think, a balanced solution to the challenges that we are facing. Yes, maybe I could stop there. Lillian.
Thank you. Thank you so much to all our panelists today. Indeed, we've seen that this evolution presents important legal and ethical questions around accountability, fairness, privacy, worker protection, and ultimately the future of labor law itself. It is therefore critical that as legal practitioners and policy actors, we engage and we continue to engage proactively with these developments and begin shaping the frameworks that will govern the workplace of tomorrow. I know that we have taken a lot of time, not a little, 23 minutes past time. And thank you to the Secretariat for adding us the 23 minutes to our discussion. As you can see, it was an important discussion that was timely, that we needed to have. We've also noted your request, and the committee will see how to comply with your request so that we continue with these discussions. On behalf of the East African Law Society, I sincerely thank our panelists for their valuable insights and all the participants for joining this important conversation, adding their voice through the conversation, through questions, through comments. This is not just a theoretical discussion, it is a present reality shaping the future of work in our region and beyond. Thank you very much. And I was requested to close this session since Gabriel is not here, and that is the end of the session. Thank you, and may you enjoy may you all have a lovely evening.
Thank you.